court was looking at on this one. The facts in this one is what you typically would think. The neighbor hops on her wireless network, gets bumped off for some reason, and she picks up the guy's, Belkin 54G wireless network. She connects on that using her iTunes, and as she goes through her library, she sees the dad's LimeWire tune. She goes, wait, that ain't mine. And she observes a few files, and this is the disgusting part of the job, and so I'll spare you the names and the titles of these things. And she calls the cops. Cops come over and say, can you do this for us? So they do it. She does it for them again. They go get the search warrants, and the next is all history. They're arresting the guy. Now, when courts are discussing facts, they usually will start tipping their hand on which direction they're going to go, on whether they're going to find it a search or whether they're not going to find it a search. The judge I used to work for, when we used to have motions to dismiss cases, I used to tell attorneys, if the judge is going to go through the facts and he's going to start talking to one attorney, if he's not talking to you, shut up, sit down because you've won your case, because he's going to talk to the guy who's losing on this. And this is what courts really do. They start looking at basically what is the aspect of unsecured wireless routers, joy routers, ubiquitous out there. So you can kind of tell, okay, well, he's going to be looking at this. And he starts doing an analysis of wireless phones and hardwired phones. Basically, you don't have the expectation of privacy in a wireless phone or wireless phone that you do with a wired phone. And that's exactly the path he goes down, saying, look, you got this unsecured wireless router. It's broadcasting out there. You don't have an expectation of privacy in what you're broadcasting out to the world from that aspect. And then they went on to say, okay, now what about just because that's aspect, what about the library that was in there, the ShareTunes account? The guy says, I could have an expectation of privacy in that. And the judge said, no, you don't, because on your iTunes account, it's defaulted to closed. You had to go and actually open it up to share it. And so basically this guy got busted for having child porn on his iTunes account. One of the big things that cops are doing now is they're hopping on LimeWire to find out where child porn is at. And this is an interesting case in where Mr. Barowie, he actually, was using LimeWire, and he tried to set it up to a point where his files were not out in the public domain. So he's actually evidencing a subjective expectation of privacy in his account. Problem was, he wasn't technical savvy. He screwed up. He never got it turned on properly, and the court said, too bad, so sad. Just because you're not technically savvy, we're still going to allow the search to be a good search on that, and so he got busted for child porn. Government workplace monitoring. This is where the Quan case is coming in. So if you are in this business where you've got, for your employer, you're looking at what's on the network. The case up there is United States versus Atkins, lays out a great summary of all the cases that talk about workplace monitoring, how to go about doing it, banners, notice to employees, training, the whole aspect on it. Quan had the whole same things. Quan was a cop, and he was giving a text pager to do things, and he said, use it for government purposes. If you go above it, anything you pay for, hey, that's on you. But they had the same policy saying anything and everything you do on this may be monitored and may be used and looked at. But unfortunately, the cop who was supposed to collect the money of everybody using this told him, said, look, I'm not going to look at this stuff. I don't care to look at this stuff. As long as you're paying for it, it's your own thing. That informal policy nullified the formal policy, and so basically that's why it went to the Supreme Court and said, you've got an inconsistent policy in this. Atkins talks about having that consistent policy going through. I'm going to come back to Quan hopefully in a little bit, because I'm going to go into Stengart here. This was an interesting case where they had a policy, and basically she had her web-based email that she would log into with her password, and she sent some messages to her attorney. They held that the policy was not clear. Now, we always say bad facts make bad law. These aren't really bad facts, but the facts of this case is you're dealing with the attorney-client privilege. And as the court said, the attorney-client privilege is the greatest privilege in the world. It's the second privilege after Adam and Eve and the marital privilege, because they went way back. Because why? They're a judge, they're an attorney, and so they want to protect their own space. In this case, she used her web-based email, her Yahoo account, or Gmail account, to send her attorney some messages. And they had a policy that said anything and everything you do on your employer-provided laptop may be monitored. Now, the court said, well, the policy was ambiguous, because then it said, this is for business purposes only. although minor personal use may be used. I've seen these policies all over the time. I'm missing where that's ambiguous. All and everything may be monitored. That's not ambiguous. And this court said it did not say your personal web-based email that's password protected that you use to send attorney-client privileges to will be monitored. That's what they said. It's a little extensive. I've heard this argument before. Yes?
So that was a legal action that she was doing. She was communicating with her attorney. Turn around. What if he was selling drugs with my partner?
See, that's an interesting point. And this is the question is, okay, so she's doing that attorney-client privilege. What if she's turned around selling drugs or something like some criminal nefarious activity? Would the court have ruled the same way? An interesting aspect.
Well, they didn't go into her actual email. What they got was the reference of, cash information on the local computer.
They basically took the laptop, did a forensics on it, and found it. Now, here's the other aspect on this one. So, again, bad facts tying into here. Professional code of conduct for attorneys. If I find privileged material, I'm supposed to not read it, and I'm supposed to notify the other side that I found privileged material and turn it over. So I've got another aspect here in terms of the fact that I have a professional code of conduct that says I've got privileged material I'm supposed to look at. There is case law out there using an employer-based email system to communicate with their attorney was not privileged communication and is not private. And that's what the attorneys were saying in this one. This wasn't privileged information. And by the way, when you turn something over to the third party, it's not privileged information. So there's arguments out there, again, and this goes with IP addresses. When I turn the information over to an ISP to transmit it for me, it's no longer privileged information because I have to share it with a third party. If it was criminal activity, would the court have come down in the same way? One aspect on this. This is a private cause of action, a civil action where two people are suing each other as opposed to a government action looking at this from a Fourth Amendment perspective. And that's what this case looked at, if I'm not going too far. They looked at the tort in intrusion on seclusion, which does look at some elements that you look for a Fourth Amendment. Objectively, is society going to look at this and the subjective intent of it? But it was an interesting aspect in this in that they said, and they did say, we're going to go cite with her. The emails should not have been read. They should have been turned over, and so they're remanding it back to see if this firm has to be withdrawn from the case. But there are some conflicting cases out there which basically do say, no, I can monitor your web-based email system. So it's one of these aspects where the judge said, we expect you to write policies to be able to monitor your network. We're not saying you can't. We're just saying you can't be looking at the content of email going to an attorney. But yet, when I talk to computer security professionals, that's the thing. Okay, this isn't, and we'll talk about this in a second here, this isn't like the old phone companies where if I monitor the first 20 seconds, I can find out where the fraud's coming from. In computer security, I never know where that fraud's going to be coming in, so I don't know if I'm going to have to look at content to see where that fraud comes through. And that's the fun challenges on this.
In a policy, if you say that you may monitor what practice if you haven't
practice.
In the last 5 years, let's say, and if you monitor one person, is that a reason to not put that in your policy?
Can I ask you to table that for a second and remind me about that, because I have a terrible memory and I'll forget. The Quan case, which I'm going to go, this was said earlier in one of the other presentations I had here. There's no one statute that discusses privacy from an aspect. It's made up of a bunch of things. As a matter of fact, privacy isn't even in the Constitution. It was created by the court on this. So it's an interesting aspect when we're dealing with privacy and when we're doing workplace monitoring. To do network security, going through really fast so I don't waste time, it came from an aspect of a common law principle about dealing with property, and that it's kind of a self-defense type principle. If you're in the right place at the right time, you can defend what you've got. It really is the trespass to chattel, and chattel is simply the aspect of it's my property. If I give you my lawnmower, or if you come over and borrow my lawnmower, and the interesting point on this one is that part where it says we like the aspect of prevention as opposed to post-action recovery. And what that means is you borrow my lawnmower, they like it if I'm actually got my lawnmower locked up in my garage so you can't get to it. If you just come over and get my lawnmower and take it over, and then I've got to breach the peace to get it back. I kick down your fence. It's the middle of the night. Dogs are barking. Cops show up. We don't like